with Mr. Williams, and I would like to please address bond whenever appropriate.
You can. I don't think it's going to change. Mr. Williams has a clear history of failing to appear before this court, but you can try.
Your Honor, he seems to be on a parole hold. He is on a parole home confinement tether. We were going to ask that he be removed. The home confinement tether be removed once proof is provided that he is on the parole home confinement tether.
He's on a confinement tether to us?
I believe on another case.
So I don't know what you're asking me for.
I mean, he's on. I'm asking that he be released since he would be on a home confinement tether.
No.
Your Honor, if I may jump in here. What Mr. Williams is requesting, he's currently on a home confinement tether in this matter. He's also going to be on one with parole when he's released. So we're asking if the court would consider removing the tether in this case once proof is provided that he's going to be on the parole tether.
Are you all back for you?
He currently has a $10,000. No, he's got a 10K PR, which I don't really want him to have at all. So there's that. I don't want him released. The reality, on January 13th, 2022, well, let me go back. So this is a case from 2021. He was in custody in Wayne County. We adjourned it to November 4th. On October 7th, we adjourned it to November 4th. He came here on November 3rd. We adjourned it again, and I gave him a $1,000 10% bond. Then he appeared in custody at that time at the Wayne County Jail and promised me he was going to come back. I gave him a PR bond. Told him to be back here on January 13th. He failed to appear. Then he got arraigned in front of the magistrate, who at that time was Magistrate Nelson. Magistrate Nelson gave him another PR bond. And then at that time, he told him to come back here on February 17th. He failed to appear. He appeared while he was in custody again. And I told him at that time he could use the MDOC tether. And then he came for those next couple of pretrials, asked for a final settlement conference, for which I sat on June 23rd. He failed to appear. So he failed to appear 1, 2, 3, 4, 5 times. I don't know why I would do that. No, not yet. Ms. Woods, is there anything you'd like to say?
Judge, we agree that he has a long history of failures to appear and also was an absconder from his parole status with MDOC. It looks like that was back in 2022. So based on all that information, even on a tether, I mean, we still have serious concerns that he would not come back to court.
What would you like to say, sir?
Your Honor, I've been in prison. I just got out of prison for 2.5 years. I just got on the 28th of January. I don't need to take down. I've been in prison.
Sir, you were in MDLC. I saw you. You were in Wayne County and not MDLC.
Right. I just on June 23rd, 2023. I've been incarcerated ever since then.
Stop it! Stop it! Stop it!
Reset point. All right, who are the parties on Jeremy Ruffinet?
That's me, Judge. That's a second from a trial we did I think back in March.
Okay, how many witnesses do you have?
None. State doesn't have any either, Judge.
Okay. Where's Mr. Raffinay?
In the box, Judge.
All right, the court is calling 2019 CR 3013, State of Texas versus Jeremy Ray Raffinay. Can I have the parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Robert Mauer for the defendant, Your Honor.
And are you Mr. Raffinay?
Yes, ma'am.
All right, we're here for sentencing. You received a guilty verdict from the jury. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
You have, Judge.
Any objections to the PSI report from either side?
No, Your Honor.
No, Your Honor.
All right, state.
Your Honor, we don't have any witnesses. We just have argument. We'll reserve.
All right, defense, I'll hear your argument then.
Judge, I'm sure the court remembers this trial. I was frankly stunned that any jury in Bexar County would have convicted Mr. Raffinay on the facts and the testimony that was put in front of it, both with the testimony from the complainant that contrasted with the testimony from her own mom. The detective, I think, did a poor job working that case up and presented the evidence. I think the court should take that into consideration when assessing punishment. Of course, it doesn't matter what I think, that he was convicted by a jury, but the court recalls, I think there were a lot of issues with what we had as far as jury deliberations that led me to believe that somebody had made it onto the jury through some sort of deception. And I would ask the court to sentence Mr. Raffinay to 2 years TDC based upon the facts of the case. As the court recalled, the allegation was a one-time touch over the clothes while the mom was out partying with her friends. And that was the entire case. Mr. Raffinay's prior criminal history involves, I think, some state jail time for theft. Judge, I would ask the court to take that in consideration when assessing punishment. And I would ask the court to sentence him to 2 years TDC since he is not eligible for probation.
All right, state.
Your Honor, defense seems to have a different recollection of the case than I do. The court heard the testimony of Angelina Straub, Christina Bigler, Eric Mata, and Detective Stokel. I thought Angelina and her mother both came across as very credible and still very affected by what happened to Angelina that night. Now let's talk about the defendant's criminal history. Defense says that he did some state jail time for theft, but he actually did more than that. So in 2016, he spent 13 months in a state jail facility for taking someone's car that did not belong to him. In 2017, he was confined for 12 months for another theft in Comal County. And in 2019, he was sentenced to 4 years in prison when he screwed up his probation again on a case where he'd taken someone's property that did not belong to him. So the defendant has a bad habit of taking things and touching things and people when he shouldn't. Let's talk about this case. He continues to show no remorse and makes no apology for what he's done. And defense may have their opinion about the trial, but the fact of the matter is a jury did find him guilty of the indecency with a child by contact. Now, Angelina had to wait 4 years. That is a long time in the life of the child. She had to stand in front of this court and be re-victimized. It was clear when she walked into the courtroom and started testifying that she was still very much affected by what the defendant did to her. And think about how frightened she was that night when she texted her mom. He violated this family in the worst way possible. Christina Bigler thought she'd met someone who cared about her and her kids, someone that she could trust, someone that would help her. Think about what it was like for her to get those text messages that night, how terrifying that must have been. And she can't be here today because her child is sick, but you heard from them in the trial. We're asking you to sentence the defendant to 11 years in prison so that for the next 11 years or the remainder of his sentence, he can think every day about how he's not supposed to touch children. 12 months wasn't enough. 13 months wasn't enough. 4 years wasn't enough for him to learn to be a better person. Give him 11 years, 1 year for each year of Angelina's life at the time he molested her. Let that be a daily reminder to him that what he did was wrong, and we are going to hold him accountable, and that when you decide to touch a child's vagina, it's going to be taken seriously and you will be punished.
All right, Mr. Rockene. The court will sentence you to 8 years in the prison. Give you credit for any time served. And there should be Chapter 62 registration. That's lifetime registration. Do you understand? I'm sorry?
Yes, ma'am.
All right, I'm going to show you what's entitled. I'm sorry, is there anything else on either side with regards to sentencing?
No, Judge.
No, Your Honor.
All right, Mr. Rockene, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. If you review that document with your attorney, did you understand it?
Yes, ma'am.
All right, you have a right to an appeal since this is a jury trial. You understand?
Yes, ma'am.
Mr. Mauer, if you're not going to,
I filed a motion for new trial. But I think I did need to withdraw and have the appellate public defenders. I'm not sure if I can handle the motion for new trial because I actually also filed a motion for the court to disclose the juror information so I could have an investigator look into whether or not anybody on the jury gave false information or testimony during voir dire. But I'm not sure if the court wants me to do that or just withdraw and let the appellate defender's office do it.
it's however you wish to proceed, Mr. Mauer, but you'll need to let Ms. Ferguson know. And if you're planning on withdrawing and he's planning on asking for appeal, then of course that needs to be done as quickly as possible.
I've got the motion for new trial filed already. We'll file the notice of appeal as well.
All right, thank you. All right, are the parties ready on Marla Garrison? Good luck, Mr. Rockene.